Can labor law override employment contracts in the United States? In recent discussions surrounding labor and employment law, a pressing question has emerged. Can labor law override employment contracts in the United States? As workers and employers navigate the complexities of employment agreements, this topic is more relevant than ever. Many are seeking clarity on how labor laws interact with contracts, especially in light of recent legal developments. Labor law in the United States establishes minimum standards for employment conditions. These laws aim to protect workers and ensure fair treatment across various industries. When it comes to employment contracts, which are agreements between employers and employees, the relationship between these contracts and labor law is crucial. The short answer is yes, labor law can override employment contracts, but there are specific conditions. Federal and state labor laws create basic rights and protections for workers. If an employment contract includes terms that are less favorable than what the law mandates, those contract terms cannot be enforced. For instance, if a contract states that an employee is not entitled to overtime pay, but federal or state law requires overtime 4 hours worked beyond a certain threshold, the law prevails. Contracts cannot waive rights guaranteed by law. Several key areas demonstrate how labor law commonly overrides contracts. First, minimum wage laws dictate that contracts cannot pay less than the federal or state minimum wage. Second, employees must receive overtime pay as required by law, regardless of what the contract states. Additionally, workplace safety regulations must be followed by employers, even if a contract suggests otherwise. Anti-discrimination laws also play a role. Contracts cannot allow discrimination that is prohibited by law. Furthermore, laws like the Family and Medical Leave Act provide rights that contracts cannot diminish. However, if a contract offers benefits or protections that exceed what the law requires, those terms are generally enforceable. For example, a contract may provide more paid leave than what is mandated by law. In the context of collective bargaining, federal law also influences this dynamic. Project labor agreements and other union contracts must comply with federal statutes. While unions and employers can negotiate terms, they cannot agree to conditions that violate federal labor law. Recent developments, including Supreme Court rulings and executive orders, have influenced how federal agencies and contractors interact with labor law and contracts. Executive orders can modify rules for federal projects, but they cannot override statutory labor protections. In practice, when there is a conflict between labor law and an employment contract, the law takes precedence. Employers and employees should be aware that contract terms must meet or exceed legal standards. If a contract attempts to limit rights or protections guaranteed by law, those terms will not hold up in court. This ensures that all workers receive at least the minimum protections established by labor law.